Hi everybody, Dave Sugden. Today we are going to talk about the business records exception to the hearsay rule. And so we start, as we always do, looking at our analytical framework for every evidence question that comes our way. We're talking about hearsay today, and specifically we're talking about one of the key exceptions to the hearsay rule that business litigators need to know. And in prior videos, we also talked about a way to recognize objectionable hearsay. And rather than just memorizing the language of the statute, that can often not necessarily foreshadow objectionable hearsay. So we talked about a working rule for hearsay is considering it as evidence where the probative value of the evidence turns on the credibility of someone who cannot be cross-examined. So if we can't cross-examine this person and the evidence matters, we may have a objectionable hearsay issue. And then also in prior videos, we've talked about how do we quickly recognize exceptions to the hearsay rule. And very briefly, the way to look at hearsay objections is to consider whether or not the hearsay we want to get admitted, is it trustworthy? And is it necessary to our case? And if there's a combination of these two things, there's likely an exception. And we want to now, with that frame in mind, consider the business records exception. Because what can often happen in trials is people will just assume that some document that was prepared by a business must therefore be a business record and therefore must qualify as a business record exception to the hearsay rule. But again, what we want to do is not just assume that because it's a business record, it's in, but rather look at the actual language of the statute to see what's required. And this goes both when we want to affirmatively get such business records into evidence or challenge business records on their lack of being an admissible business record. And so again, we talk about having these working rules, and let's do that now looking at the business records exception to the hearsay rule. And so for example, in California, we will look at California Evidence Code section 1271. 72 is the absence of a business record. And in the federal rules, we will look at Federal Rule of Evidence 803.6, and 7 is the absence of the business record rule. And the first thing we want to look at is what kind of business records are allowed. And under section 1271, it limits business records to records that record an act, condition, or event. This is important language because oftentimes business records, people will want to get business records into evidence that go beyond describing an act, condition, or event. For example, look at the case of People versus Rays. In that case, one of the parties wanted to admit into evidence a number of therapy records where the criminal defendant had been meeting with a therapist and the therapist wasn't available. And so they wanted to get into evidence all of the therapist's notes, which included the therapist's opinions as to the defendant. And so, yes, all of these notes were made in the regular course of business. They were met at the time the therapist met with this patient, and they were made in real time, so the identity and mode of the preparation was all legitimate. The problem is that the records offered opinion evidence. And what the court said was, we don't know the qualifications of this therapist. We don't know if he or she's opinions were valid, whether there was an appropriate foundation for them. So they're not business records, they're not admitted. So we always want to consider first whether or not these business records record an act, condition, or event. In the federal rules, opinions and diagnoses are permitted, but remember, just because they may be permitted as a business record doesn't necessarily mean the the opinions are admissible. And you'll want to go to issues related to the opinion testimony's admissibility in trial. Once we've determined whether or not there's a record of an act, condition, or event, we'll then want to look at these pieces that are all identified in the statute. And what we see so often in depositions as well as during trial, as what we see is lawyers essentially treating these requirements as checklists to simply ask and get a very rote response. And so you may get a leading question from the proponent of the document saying, well, was this made in the regular course of business? Yes. Okay, was it made at or near the time of the event? Yes. And there's a lost opportunity here because, again, as the proponent of the evidence, not just getting the document admitted into evidence, but you also want to establish, as a matter of persuasion, the trustworthiness of the document. And so you want the witness to describe how in the regular course of business this document was created and why was it created and when specifically was it created in relation to the act, condition, or event that was recorded. And then also you'll want to talk about how was this document created, how much time it took, what were the source materials, what was the method, because all of these things have to go to the trustworthiness requirement. Both in California and the federal rules, there has to be a showing that the document is trustworthy before it gets admitted into evidence. And so these are the elements of the statute you want to hit, and as a matter of persuasion, you want to make sure these witnesses are prepared to explain that this happened and why these documents are trustworthy. So that is the business records exception to the hearsay rule. If you like this, I would encourage you to check out evidenceattrial.com and look at live events we have upcoming as well as our online classes. Thank you again for joining our community.